Ready? Start. In the judgments of two civil appeals, the first one by Harinagar Sugar Mills Limited, Biscuit Division, and another against the state of Maharashtra and others delivered on June 4, 2025. Justice Sanjay Karol and Justice Prashant Kumar Mishra at the Supreme Court have held that application of August 28, 2019 was complete in all respects and the 60-day period of demand closer to take effect would be calculable from said date para. Second, the Deputy Secretary was not the appropriate government who could have asked HSML to revise and resubmit the application for closure. The authority is vested only with the minister concerned. The minister did not even in the slightest consider the merits of the matter independently, much less with or without any application of mind. Subdelegation to the officer was not permitted by law, and therefore any communication made by him would be without any legal sanction para. The Supreme Court has allowed the appeals. It is, however, clarified that the money paid to the employees by order of the High Court during pendency of the writ petitions would not be recoverable from them. At this stage, the Supreme Court referred to the order passed by it while reserving the matter for judgment para. In the said order, the Supreme Court has recorded statement made by the senior counsel Rohtagi on instructions that a sum of rupees 4 crores has been already deposited. In addition, a further sum of rupees 10 crores can be paid by the petitioner to the respondent workmen. He has clarified that the said amount would be in addition to the amount of gratuity about rupees 4 crores which the workmen are otherwise entitled to para. The entire sum, that is the amount of gratuity plus the enhanced amount, can be distributed as compensation amongst the workmen who may be eligible and entitled to for being on the rolls of the company. This, of course, is by way of an endeavor to put an end to the controversy and without prejudice to the respective rights and contentions of the parties para. Considering that some of the employees may be with the closure of this concern losing the only job they have known, and still others would be for no fault of their own rendered unemployed. The Supreme Court appreciated the gesture made by HSML. Such a statement was taken on record para. At the close of hearing, after giving thoughtful consideration, the Supreme Court thought it just and proper to further enhance the appellant's offer by a sum of rupees 5 crores, thus making it rupees 15 crores instead of rupees 10 crores. Let the amount be released forthwith as per their entitlement in favor of the employees, and in any case not later than 8 weeks from the date of the judgment para. Through these appeals by special leave filed by appellants here in correctness of a Bombay High Court judgment of February 17, 2023 in rate petitions 3447 of 2019 and 3397 of 2019 arising from SLPs was challenged para. Reasons are important and ought to be recorded. It could be said that the conclusion reached by the office of the minister that HSML had not supplied sufficient reasons for closure itself would be sufficient to qualify as reasons. However, can be an endorsement of the view taken by an undisclosed officer of the ministry be said to be an application of mind by the competent authority when the minister is the sole authority. The court stated that it did not think so. Para. The conclusion of insufficiency of reason was reached the minister, and then they would have directed the deputy secretary to communicate the decision to HSML. Then our conclusion may have been different. Para. The necessary conclusion is that the letter of September 25, 2019, addressed by the deputy secretary to HSML, cannot be constituted to be an order, since such order to resubmit the application was without any authority, since it was not the appropriate government acting in that regard, and not an order rejecting or accepting the application. The same conclusion can be reached on a second count. The order suffered from the vice of non application of mind by the competent authority. Section 25O of the ID Act provides that the appropriate government may, after making an enquiry and hearing all the concerned parties, pass an order in writing accepting or rejecting the application for closure. It also provides that if the appropriate government does not communicate an order within 60 days of the date of application, there shall be deemed closure. Para. The Supreme Court has stated that it had held that the appropriate government had not acted in respect of the application made by HSML, since the minister, who was the competent authority, had not applied his mind to the administrative order, nor did the deputy secretary have the authority to do so. In other words, the appropriate government failed to make and communicate any order on the application for closure. The deemed closure would therefore come into effect. Para. Separately, the Supreme Court has observed that the reasoning furnished by the Deputy Secretary to reject the application for closure made by HSML is insufficient, and it appears to have been given for the sole purpose of rejecting the application without the application of mind. Para. An employer seeking to close his business must compelling and overriding circumstances. The application for closure clearly states that thus BIL Britannia Industries Limited has terminated the job work agreement with the biscuit division, and the said provision has no other manufacturing avenue. Since last 32 years, the said division was manufacturing biscuits only for BIL, as the biscuit division has no alternative but to close down the manufacturing activities. Para. Further, the HSML has clarified that since inception it has done no job work for anyone else, and that now there is no further scope on executing work for anyone else. The court is quite certain that it spells impossibility. Para. In the light of material on record, the Supreme Court has held that there did indeed exist sufficient compelling circumstances for closure. The High Court erred in placing reliance on Form 25B instead of 25C, which resulted into an erroneous appreciation of statutory provisions.